How long before the folks across the street come to us and say, we can't afford you anymore? And that's the other reality, is how many people do we lose in town, and particular senior citizens? Where are they supposed to go when we start taxing them out of their homes?
Now, I think that's, I don't see any more questions for Leslie, Pat, or Kurt. I think the question for the town manager and the finance director is, A, we have a few more agencies that are covered on Monday night, October 30th. And B, the question of, I think Mr. Shaken asked the question of the hour, which is how much is this all going to save us, and how, even if we did the worst of the worst. And we, as you've heard, we don't know that.
Do you want to take it?
I think that the way Ms. Moran phrased the question to us or posed it to us definitely provides Ms. Tran and I with some guidance where if we were to pick the worst of everything and everything we've been able to put a dollar figure to. So we will do our best to try to have that for you for the 30th as you begin your conversation around prioritization. What would also be very helpful for us is once we get past talking about public safety and education and we get to talking about your priorities, if you could, just like a budget workshop or your goal setting workshops, if you could come prepared to tell us what's most important to you to keep, what you feel most comfortable shedding, or what you might feel most comfortable modifying. If you can give us some sense at that meeting, that would be very, very helpful to us.
I would make a request for anybody who does not save their packets from week to week. I would want the packets for every agency in town, all 3 weeks worth of presentations, even though you've already given them to us. I want them again for the next meeting. Anything else from any members of the council? Ms. Keene?
That next meeting, we're obviously going to be really tearing into this. Will we have the opportunity to actually enact some policy decisions, or we're not just discussing, right? It'll be a working, where we can make motions to start making decreases as of December 31st.
That, well, actually, given the notice period, it's a special meeting, and the agenda has not been finalized. So if there is a sense of the council that that's what they'd like, then it can be part of the agenda. One of the things that I'm mulling over in my mind in response to Denise's question is, if in a special meeting, you cannot add anything to the agenda. So it's either on the agenda or not. Ms. Moran?
Why don't we put an item on the agenda for taking action if appropriate? Some kind of general thing that allows us to make motions regarding cuts. We don't have to say specifically what department is going to come up, but all we need to have is an agenda item that says that the discussions and actions on potential cuts are may be made at that meeting.
Yeah. Ms. Trahan?
Just one comment. If we don't have a budget at that point and we don't know what target we're looking for, if you make a motion to do, say, a certain reduction to reduce, say, the library hours by so many, that may ultimately not be enough to cut we get. So I just don't know if you want to hold off those motions until.
Okay, in terms of the discussion, Ms. Keene, followed by Mr., you can finish, and then Mr. Shaken goes next.
I totally understand that, but I'm in agreement with Virginia that we need to start doing something. So even if we were to do initial slight cuts or whatever we thought was appropriate, we need to start saving.
And I would also add, it just came to my head, that there could be couched in language on the assumption that there is no state budget is enacted. I think that if there's a state budget enacted, then the target stops moving. And Mr. Shaken, yes, sir.
Yeah, exactly what the mayor just said. If there is a state budget, unless it makes wild and drastic changes from any proposal that we've seen from the governor or the legislature since February, we will not need to reopen our budget, period. We have a surplus from last year. We have frozen a significant amount of capital spending. I mean, we may need to make several small adjustments, but if there is, unless there are drastic changes in this bipartisan deal, if it passes, this is solely if we have to live out the year under executive order. We have a target. It's not moving. It's $14 million. It's not changing. That's the target. Unless a budget's passed, and then we will, maybe with some minor adjustments, go back to business as usual for the remainder of the fiscal year.
Mr. Ryan.
In response to what Tony said, as well as Ben, I think we could always make the cuts take effect on, say, January 1st, or whatever date we wanted, and we could always rescind those cuts if we get a budget after then.
Of course. Okay, Ms. Capriola.
So just 2 points I would like to make. Ms. Trahan and I, as we've been reviewing this, again, we've been providing with you estimates for mid-year savings with anticipating that you would enact these changes for January 1. We were thinking, receiving some direction from you definitely by November to make those changes for November 1. So I do think that is important. In terms of current year, to Councilmember Shaken's point, if we're looking at something more in the range of a $2 to $3 million cut, if you'll recall, I believe it was our August 28th meeting, we did provide you with what I would call a short-term solution for getting us through that would not impact services. So I do just want you to remember that you do have that essentially plan that we outlined for you, minimum service impact, and that's again a range of about a $2 to $3 million loss for current fiscal year. It's really, if it's anything in excess of that, where we're talking about for current year for reducing services.
Okay, again, Mr. Ryan.
Is there a date after which we cannot issue a supplemental tax bill?
Ms. Trahan.
Not that I'm aware of. Of course, it would be most cost-effective if we can do it when the January bills are due. That would be ideal.
Mr. Katzenberger.
Just to follow up, I want to make sure, I don't agree with I don't want to mix, well, hopefully, I don't want to leave an impression that, in fact, the town, of course, has not made any savings and not had any reductions. In fact, we've been operating as the town, as we've talked about at numerous meetings, and we've had reports on deferring many projects that we otherwise could have started. So in fact, we have been planning, and I think actually next Monday would still be premature if we don't have a budget, but it doesn't hurt to allow us to have that right by putting on an agenda. But we don't want to make these cuts, as we've all said repeatedly tonight and as well as previous weeks, and we're not going to make these cuts if we don't have to. So I don't think so I think we actually have been planning, much thanks to the town staff, prudently so far. Obviously, if we get a $5, $10, $14 million cut, we're going to have to do more drastically, but to prepare for that in the sense of starting to make cuts now, or even I think next week, absent a budget that dictates it, I think is premature.
Thank you. I believe that should conclude our discussion. You've gotten some feedback from us. I think you know where most of us stand. Thanks for this work. I wish you did not have to do it. We're going back to our agenda. Item 3 under new business, the discussion begins in your books at page 29. And again, Ms. Painter, Ms. Mullen, please come on up. One thing I want to clear away at the start. I appreciate the comments of the speaker this evening. But one thing that I will mention, and that Ms. Painter and can elaborate on, or perhaps Ms. Capriola, we do not enact zoning regulations. We did not do this. We have no authority to change it. This is an action of the Planning and Zoning Commission, and they, and only they, under state law and our town charter, have the authority to take any action on zoning regulations. We've received sufficient comments so that it was felt fair to put this on the agenda and to have us, so that we might gain a better understanding of this issue. Ms. Capriola.
So we have included this informational presentation at your request. As you'll recall, at the last meeting under my town manager's report, I did provide a brief overview to you. One of the questions that has come up is, why did you have the public comment process on this when students weren't here? I think that one thing that Ms. Painter and Ms. Mullen can speak to this evening is the fact that the public input process for these changes to the zoning regulations did in fact occur in the spring when the students were actually here. So that's something they'll be able to elaborate a bit more on this evening. What I've asked them to focus on for us tonight is just, again, explaining that process and explaining how the definition of fraternal organization was broadened. Also this evening, they have brought copies for those of you. Our town attorney was involved in reviewing the revised definition. He did provide an opinion to the Planning and Zoning Commission. He did feel that the revised definition was acceptable. And we are just going to distribute a copy of that for you for your information this evening. But I would just ask Ms. Painter and Ms. Mullen to provide a brief overview in terms of the change in definition of fraternal organization, and then just open it up for questions.
What?
Within that, Maria, could you also say not only the definition changed?
Wait, Peter, do you want to be recognized?
Yes.
Sure.
Thank you. Trying to be efficient here. Not only to make sure that the definition was changed, but what the implication for that change is. How does it fit within, because when we look at the memo, it clearly notes what the definition was and is, but how that fits into the statutory enforcement.
Okay.
All right. The agenda item summary that you have, I'm not going to go through it in all detail. You had that as some preliminary workup, but I will give you some background on this change that was made by the Planning and Zoning Commission last spring. In fall of 2016, as part of our enforcement efforts, it came to our attention that we had some challenges with our current definitions of fraternity and sorority. And in particular, it came because we had a complaint about a fraternity event. We did issue a notice of zoning violation, and we discovered after we had done that they were not a fraternity that was covered under the definition. And so as we started to look at this, and we detail this in the memo, we had some challenges with our definition of fraternity and sorority. One, it cites an office that no longer exists at the university. They have since changed the office that is responsible for Greek organizations. They've changed the name of that. It used to be the Office of Greek Life. It is now the Office of Fraternity and Sorority Life. Secondly, it was limited to fraternities that were recognized by the university. So that was a challenge for us in that when the university essentially suspends a fraternity or sorority for various reasons, they become what is called an off-campus organization. In some cases, those organizations continue to operate. And if an off-campus fraternity or sorority has a party, technically they were not considered a fraternity or sorority under our definition. So the only ones that were subject to this were the ones that were officially recognized by what is now the Office of Fraternity and Sorority Life. So that's really where we started. I think the other piece of this that came out in I want to say it was the Ad Hoc Committee on Rental Regulations and Enforcement actually had the university come in and speak about fraternities and sororities and some of these issues. And I think it was that presentation where we also learned that really the fraternities and sororities that are part of fraternity and sorority life are a very limited number of organizations. And I think we go into that in more detail in the memo, but that really you have hundreds of student organizations that are out there that were not subject to these rules. And so as we looked at this, we started talking in the winter with the Regulatory Review Committee, which is a subcommittee of the Planning and Zoning Commission that kind of deals with regulations on a regular basis. And they agreed that, yes, they thought this was something that we needed to do some work on the definitions. And so we spoke with them initially, and then we brought a recommendation to the full commission in March. And at the March 20th meeting, the Planning and Zoning Commission voted to schedule a public hearing on the proposed changes for May 1st. That hearing was advertised in accordance with state requirements, and there was also an article actually on March 21st in the Daily Campus talking about the proposed changes and when the public hearing was, and that public comment was being sought. So the hearing was held on May 1st. I believe we had 3 speakers that commented, and I believe all of them actually commented in support of the proposed changes. And with no other speakers, the commission closed the hearing that evening. They then deliberated. There were other changes as part of that package, so they were deliberating on some of the other changes not specific to the definitions of fraternity and sorority, which was changed to fraternal organization. And ultimately adopted the changes on June 5th. As Maria mentioned, as part of this process, we did refer this to the town attorney. That is routine. We do that with any changes to the regulations, regardless of whether they're being initiated by the commission or by a private citizen. So that is something that we would do with any change to the regulations to make sure that what we are doing, that we are on good legal footing with those changes. In this particular case, Attorney Deneen did review it. His review is actually under number 2 of the letter that you have before you. We had several items that we had sent to him at the same time. And his comment is the proposed regulation amendment to fraternities and sororities is acceptable as drafted. He did note that if the changes in the definitions is accepted and adopted, it will be important to make the appropriate language changes through the regulations, which currently refer to a fraternity house or a sorority house. So that was the sole comment that the town attorney provided with regard to the proposed changes. So given that, if there are any questions about this process, we'd be happy to answer them.
I see 3 hands. Actually, I'm going to recognize myself first. The first piece is there is no analysis of any associational rights or any issues that might have been raised by the expansive nature of the definition of what's covered. We all know, or should know, that fraternities and sororities have not been allowed in Mansfield residential neighborhoods for many, many, many years. The question, though, is whether this is actually not in our ballpark, but the question comes up anyway. Is this overbroad, infringe on associational rights? And do you know whether that question was ever raised or the town attorney was directed to inquire on those issues? Because there's nothing in number 2 that addresses those issues.
So I can say that I think early on in this process, we had heard some comments that were coming out in meetings regarding the constitutional right to assembly. And, I did have a brief conversation with the town attorney about that, and he did not feel that was a concern. Especially since for the most part, and I think Janelle can address this in terms of the enforcement piece, in terms of enforcing this, we need to know that this is actually an organizational event, that there has to be a nexus. We can't simply say, oh, there was a party at this address and someone saw someone there wearing a T-shirt with the name of an organization and therefore jump to the conclusion that it was an organizationally sponsored event. There needs to be some evidence for us to move to a zoning violation. And I think the other piece I wanted to say on this is that this really primarily affects residential neighborhoods. And that is something, this is about land use. This isn't saying that you can't assemble anywhere in town. There are districts where these uses are permitted by special permit. They are allowed by special permit in the planned business zone at King Hill Road, as well as in the institutional district, which covers the UConn campus. It covers other private properties as well on North Eagleville Road, as well as the town and regional properties. So this is not about prohibiting assembly townwide. It's about saying, here are the appropriate locations if you want to have this type of use.
I'm going to go to now the questions. Ms. Moran, and then I'll then get to the other side of the table.
Here's where I have a problem with this. Suppose you have a house in a residential neighborhood where all three residents are members of a club or team, and they're just all friends, and they live there because they hang together. And they decide to have a party to which they invite their other friends who are all members of the same club or team. How do you distinguish that event from a prohibited event?
So typically, when I do hear reports of any activity that would trigger this violation, it comes from the police department. So it will come as a result of citations that were issued for nuisances. So hypothetically, if there were to be an organization and they're associated students and they're all under the same realm and they're organized and they're having their party, if it's not brought to my attention because of a nuisance violation, I honestly will not be notified of it unless a complaint comes into my office. And it very often, the one instance where I've issued one notice of violation under the new definition of fraternity is essentially when the police officers issued 6 nuisance violation to various attendees, and in a hearing, they openly admitted this was a fraternity-sponsored event. So as Linda mentioned, the nexus is extremely important, that there's the property and then it's tied into the organization. And very seldomly will I ever move beyond a notice of violation, because the nature of zoning regulations and the zoning citation ordinance, I will issue a notice of violation. There's a 10-day period for that violation to cure, for the property to come into compliance. Within those 10 days, I assume that this activity would cease to exist at the property. If it's a regular occurrence where it's a fraternity organization or another club, et cetera, organization hosting regular parties that are brought to my attention either to because of a threat of safety, welfare, and the well-being of the neighbors, then it would escalate to a citation. But again, in this semester, I've issued one. It was a notice of violation, just stating the violation, no fine attached to it, relative to a fraternity party where 6 members all openly said in a hearing this was a fraternity-sponsored event.
And one more.
So how do you distinguish between an event to which all the attendees are a member of an organization and an event which is an organizational sponsored event? How do you make that distinction?
The difference would be, so for this notice of violation that I'm thinking of, there was a very clear registration with the university of an event taking place at this particular property, and then there was also open testimony to the town. This ex-fraternity was involved at this property with this event. So if there's any doubt as to what organization is attached to an event, or if it's just a group of individuals having an event, I would not feel that I have substantial evidence on which to issue a notice of violation or a follow-up citation.
Okay. Mr. Katzenberger, followed by Ms. Raymond, if she's still, she had her hand up earlier.
Thank you. I have a couple of questions. So the focus here is on events. At least that's what we've been talking about. So let me ask, so first of all, I guess is that correct? But secondly, if the Yukon Chess Club, who goes, let's say there's a house in a rural, RAR 90, this doesn't allow fraternities or these kind of organizations, but someone happens to live there and wants to have a chess party, of the Yukon Chess Party, would that be prohibited under this regulation?
Technically, it would be in violation. Would it be brought to my attention if it was a result of any infringement upon the safety, welfare, well-being of the neighboring properties, and I were to hear about it, and then there would be that strong connection to that particular organization, be it a publication that went out or a report from a police officer, anything along those lines. Very typically, this comes to me from the police.
Right, so that's a distinction between what the town theoretically could do and what practically we would do. Same answer if it's the Mansfield Chess Club, right? What happens if it's the Mansfield Democrats or the Yukon Democrats that want to have get together? I mean, I'm not trying to, the reason I'm answering this question is because I think this is with all the best intentions, and it has nothing to do with the enforcement discretion, which I respect. I think this is very broad and cuts into potentially areas of speech. And this is, I would like, even though we not only did not draft it, cannot rescind it, but I think any amendment, any law in the town of Mansfield, when with the town council that goes as far, should at least be subject to more review by the town attorney, specifically as to whether these definitions as expanded, and not necessarily where you live. I think that's a very different issue. I think we can say the Yukon, the Mansfield Chess Club can't have an organizational home in some of these districts. But the fact that they couldn't have an event simply because it's organizational as opposed to social is, I don't know if that's supportable.
All right.
And I think our town attorney, I think our town attorney has to, specifically look at this, because, he may be, he's the expert, not me. He may be able to look at this and say, no, here's the case law that allows this to be done, or with proper, discretion in terms of enforcement. I don't know, I don't think it goes that way, but I'm not a First Amendment expert. But I think it's significant enough that it needs to be reviewed by the town attorney, regardless of what we can do with that advice once we get it, but I think we need it.
1 second. You want to, first of all, I don't know if there was a question in there, but if there was, you can respond. Ms. Raymond, followed by Mr. Ryan, are the next two in the queue. Do you wish to respond, Ms. Painter, or?
I guess the only response I have is this was, again, we refer everything to the town attorney, and we rely on the opinions that he provides as part of that review.
No, actually.
Well, I wanted to, excuse me just for a second. I want to make sure I'm not criticizing staff at all, or Kevin.
You are not criticizing any person.
Right. I just want to know the process and then what we can do next.
Then the next hand I saw was Ms. Raymond's, followed by Mr. Ryan.
Yeah, I guess going back to an earlier comment, I'm probably not going to quote it precisely, but it's like what gets reported to you. And I think that's at the heart of what, live and let live unless you get reported to us. But isn't there enough law? And I'm kind of going full circle. I know that we had these issues and we had the whole committee and all that we were trying to deal with, and I'm kind of like going full circle on this whole thing is that, what people want to be able to control or address are nuisances, rowdy parties, and that kind of thing. And I think this is going way too far. I mean, why do we even need it in, frankly, our zoning ordinances when there is certainly enough body of law on the books to deal with rowdy parties or, disturbance of the peace, those kinds of things, because this is like, I kind of think it's what you're saying. To me, it's crossing a line into the association, the assembly, where, people are, until it gets reported because somebody has a problem with that group. They don't like chess players. And so they get reported. And there's nothing here that talks about disturbances or that's really, or, they just don't like that there's those three people.
Linda and I were talking about this point prior to this meeting, just in preparation, and Linda basically raised the argument that if somebody's going 30 miles per hour in a 25 mile per hour zone, typically it won't come to any law enforcement's attention. However,
All right, let her answer.
However, in situations whereas someone is going well beyond the limitations of the law, it tends to come to the attention of others, be it a report or an in-house report. I am very diligent about the work that I do, that any evidence that's gathered from the outside, I can also back up with a source that I find credible to myself, should I ever find myself in court or needing to back up actions that I've taken as a zoning enforcement officer. And so those reports coming in, it won't just be a gentleman that's upset that he didn't get to sleep on a Saturday night and is like this frat outside next to me is
That's your personal
partying.
discretion, and you're not a law enforcement person. You're not. You're not.
Agreed.
And it's your personal judgment. And I'm simply saying, unless it's a law enforcement officer that's dealing with and has that discretion, you're technically supposed to enforce this. That's your job.
And that's where I do rely on the law enforcement piece of it to bring these.
You know what I'm saying?
I do understand. I
It's like,
definitely
oh, I'm going to let it
understand.
go here, but I'm not going to let it go
I
there.
want to have a byplay. If there's a
I wanna
question
add
and an answer is
something
okay.
as well. Zoning is not a good behavioral tool. Zoning is a land use tool, so we really don't. This is one of the most difficult definitions to apply and to enforce and to work through. However, if we're mute on anything in zoning regulations, it's basically assumed that it's prohibited. So this comes up often with adult entertainment. Legally, you can't not mention it in your zoning regulations because
Or as a
allowed.
slight
One, let her
area.
finish.
or
No,
a
let her
slight
finish.
conduct of organizations sponsored.
No, wait a second here.
Assemblage. We're simply.
Wait a second, Ms. Mullen, you were answering the question. Continue your answer. No,
I heard it.
So therefore, if we were to just omit any mention of fraternity or sorority, in doing that, we're prohibiting that within Mansfield because it is not mentioned in zoning regulations.
Mr. Ryan, followed by Mr. Shaken.
I'm a little confused as to why we're even talking about this. We don't have the authority to amend the zoning regulations. We don't have the authority to rescind. And the attorney has already spoken. He's said this is acceptable. So why are we doing this?
Thank you for the rhetorical question. I'm not going to ask for an answer from staff. Mr. Shaken.
Well, I'll answer it. I think we're doing it because some of us, at least, feel that there is a significant constitutional question here. And while I understand that Attorney Deneen reviewed this, I'm not satisfied with a two-sentence answer. So while I understand that we don't have the power as a council to amend or revoke or anything this ordinance, we do have some regulatory authority over its enforcement. And so I would like to request that we ask Attorney Deneen to be a little bit more effusive in his response to why he felt that this is acceptable and whether he could comment on the constitutional issues that I think some of us are worried about. I at least feel like we definitely needed to update this definition. I'm glad PZC took a look at it. It's been, like I said, another issue earlier that we know we've run into issues with when it comes to enforcement about some of our neighborhood issues. However, while we can't change it, we may be able to affect its enforcement if necessary, and I'd at least like to hear maybe from Attorney Deneen at a future meeting directly about his opinion so we can ask him questions about its constitutionality before we make any kind of decision about making a request of PZC to relook at this, about changing any enforcement, that kind of thing.
Ms. Moran, I did see your hand first, then Ms. Capriola.
The Committee on Rental Regulations spent a great deal of time at trying to figure out what the issues were with these really problematic neighborhood parties. And it became clear that the most problematic houses were houses which were organized around a particular student organization. I mean, there are lots of places where there are one or two or occasional parties. I had a party at my house on Sunday. A neighbor could have complained. Fortunately, we kept the noise inside, and so nobody did. But unless the kids playing croquet may have made some noise, but nonetheless. The issue was organizations that disturb neighborhoods. It wasn't organizations that operate entirely within our rules. Those were not our issues. The issues were organizations that violate the rules and do so repeatedly. I think that by putting this definition into the planning and zoning regulations and then defining how it is enforced by disturbance and misbehavior, accomplishes the goals that the committee was really after. And so while I am in fact somewhat concerned about the very fuzzy line between a social gathering and an organizational gathering, I think that when the issue is modified by how it is enforced, it may solve my problem. And from a very practical perspective, it does solve the problem that was raised in my committee.
Ms. Capriola.
What I would suggest is that I have a conversation with Attorney Deneen in terms of what would be appropriate for this body to ask of him related to this matter. I know a number of folks have mentioned this evening, as I did previously, I am somewhat sensitive to the fact that the Planning and Zoning Commission, as a separately elected body, does have jurisdiction over the creation of zoning regulations. So in terms of what this body is asking of Attorney Deneen in regards to a zoning regulation, I think I would like to work through that a bit with him and see how we could best approach, if I'm understanding what some of the council members are asking for in terms of concerns about rights of association or free speech and how that relates to the zoning regulation.
I think that's fine, and I want to recognize myself again. There are one issue that Bill mentioned. This is, to a large extent, this is a separation of powers question. This is not within our authority as a town council. It just isn't. And saying that we want to talk about it or that we're concerned about the issue doesn't make it a town council issue. This is a planning and zoning issue. I also want to discuss very briefly, I think, one of the things that led to this. I read several times the police report about the tragedy in the driveway of the Yukon Fire Department. That was a party. It didn't violate anything because there was no report of excessive noise, but yet the police report of the party indicated that there was basically no control over underage drinking. Many people, not everyone, many people at that party were completely drunk, tragically including the victim and all of her friends. So this was, I think, a serious attempt by the Planning and Zoning Commission to address these kinds of problems. And what kind of fraternity was it? It was an academic fraternity. It was not it was not part of the Greek life system. That's my best understanding of that report that I read several times. If I'm wrong, you can correct me, but I read that report several times, not many times. So we have those problems. That doesn't downplay Mr. Katzenberger's concern. I think that the First Amendment issue is a freedom of association, is less a free speech issue than a freedom of association issue. And I completely understand the issue. It's a very legitimate issue. The conundrum that I face is that we don't set educational policy, and we are therefore not going to delve into the operation of the public schools. We don't set land use policy, and therefore we don't and shouldn't invade the province of the Planning and Zoning Commission. I think Ms. Capriola has come up with a solution, which is to discuss it with the town attorney. I'm also happy to discuss it with the chair of the Planning and Zoning Commission myself about our concerns. I'd like the issue to basically leave our agenda and move on, so we can move on, but Mr. Katzenberger.
Yes, I mean, I think we should discuss this as long as we need to discuss it. It's an important issue.
Quite sure.
But, so I think we need to, I mean, I don't think there's a person at this table who thinks that we have jurisdiction over the planning and zoning ordinances. That is a non-issue. It's like a straw man argument. The issue isn't that we should look at this so we can amend it. We all realize we can't. But we are the primary policy-making body for the town. That gives us, I think, not only the right, but also the obligation to at least understand if there is something in town that might be, not is, but that might be clearly violated the First Amendment. And what we can do with that is a separate question. But if we're looking for a statutory hook or enforcement hook, we certainly have one, and Virginia and Ben both mentioned it, which is, the fact is the enforcement, the fines is our jurisdiction, and we're certainly not going to be fining people for ordinances that may not be constitutional. We can't do that. So I think we have an obligation overall to understand what's going on. My only concern with what Maria proposes is that I'd rather not get a comment back that, yeah, we discussed it and it looks fine. I want something concrete, whether it's a memo or whether it's a visit here or something, but I'd like to know, I think we're entitled to know the reasoning on this issue. If this was, the number of feet, there's many zoning regulations that, not only are within the authority of planning and zoning, but also don't rise to the level of a constitutional issue. This may do so. And, for example, if you look at the definition of fraternal organization house, I was very glad to be at the party that Tony had on Sunday, but it meets this definition squarely, and it's not allowed, and that's not what we intend. So I don't know how to say it any different.
Thank you. Ms. Keene?
I've got a question. Clarifying type thing. I understand the need to update the definition. Clearly, it needed to be updated. The definition is embedded in some zoning regulation.
Make sure you're on the mic,
Okay,
Denise.
my understanding was to prohibit the fraternities, sororities, and their residential, because we've had that forever. Is that where the definition was embedded in that kind of a regulation, correct?
So the initial, the two definitions that we're talking about have been in the zoning regulations. So the fraternity sorority was defined as any group of persons organized for a common purpose, interest, or pleasure and recognized by the Office of Greek Life.
And it got updated to the new one.
And it got updated to the new one.
So the regulation that was applied to was regulating them in residential areas, or?
So the fraternity and sorority defines kind of the organization. The fraternity sorority house, now fraternal organization house, that's the land use. So when you look at our lists of permitted uses in various districts, the fraternal organization house, formerly fraternity sorority house, would appear in a few districts. Does not appear in any of our residential zones. So it was not, and if you're not listed as a permitted use, either by right, by site plan approval, or by special permit, you are prohibited in that zone.
All right, so then, if you're looking at that definition of the house, was there any discussion of planning and zoning about changing that little word "or" to an "and"?
Not that I recall.
Because when they changed the definition and made it broader and more general, maybe changing that little word in the middle could have avoided a lot of our consternation here.
I think one of the things that they were trying to deal with was recognizing, again, that there were a lot of organizations that have events, that they are sponsoring events at houses in neighborhoods that may not necessarily be a place where it is a house that is owned or leased by the organization for the purpose of housing its members. So I think that's the reason the "or" was there to begin with, and there was not a discussion about changing that, to my recollection.
And yet, we do have these nuisance ordinances, and now we're in conflict.
Okay. Proposal has been made. We actually could just continue discussing it. We could. But that the town attorney be brought in and asked if he could elaborate on his response. I am perfectly willing to speak to the chairman of the Planning and Zoning Commission about what our interest is and why we're interested in it. And I think that should, I hope, cause the matter to, I don't mind it being a recurring agenda item at all. If it needs to come back, it needs to come back. But I think the initial steps would be to contact the town attorney and the chair of the PZC. And I think whatever comes with that, that needs to be reported back to us.
Mr. Mayor,
All right.
one comment. I went back to look at the definitions again, and this is clearly designed for organizations that are UConn student organizations.
That's even more of a problem.
Okay. All righty. Then I will have a response from Ms. Painter, and then we're going to move on to the next agenda
I have
item.
one
Go
more
ahead.
comment after that, Mr. Mayor.
Oh, of course. Go ahead. Would you like to respond to what was posited by Ms. Moran?
I would just say that I think we are very careful in these regulations to not use the term student organization. And in our interpretation of this was actually brought in to include all organizations. We did not, and that was actually something that I think one of the reasons that this became very public and highly publicized is their UConn in its efforts to advise the student body of changes to the regulations actually took our definition of fraternal organization and called it a student organization. And that was something we actually had to reach out to them and say, no, this is not a definition of student organization. It's a definition of organization, period. Okay.
Ms. Raymond?
Yeah, I put a period on my thoughts on this. It's just, I'm not sure it's even needed anymore. That's what I'm getting at. Whether it's a party at Counselor Moran's house on a Saturday night, or my house, or at a fraternity house in town, if something's going on there that is rowdy or noise, somebody's going to pick up the phone and call the police. And it's up to the police to do whatever they would do, whatever courtesies or things that they would extend to any other party for anything. I'm not sure this is needed anymore. And the way it's written, it shouldn't be up to your office to determine those things. It's up to the police.
I understand your position. I will have one response, and we are going to move on. And then I'm going to make a ruling that we're on the next agenda item, and then somebody's going to have to make a point of order to stop that. So go right ahead, Ms. Mullen, respond, and then we're done.
To Ms. Raymond's point, I completely understand. That's why oftentimes I do stress that zoning as a land use tool does not often tackle the behavioral issues that we see, especially in university towns. So we use the tools that we have. The way that also the zoning violation ordinance gets enforced doesn't really make it the most practical tool to tackle a neighborhood disturbance that one might see, whereas the police are the much better agent to deal with something disruptive to that level. Zoning regulations, I'm back in my office, I write a letter, it gets followed up, it has 10 days, it has 30 days of a hearing. So I often stress that the behavioral issues using zoning and using zoning regulations and using zoning code often don't get to what one is looking for as an immediate relief to the situation or to the situation at hand.
Thank you both. And I think, Ms. Mullen, you're not involved in the next item, but Ms. Painter probably is.
Thank you.
So stay right where you are. Under new business,